Joining us tonight, criminal defense attorneys Molly Parmer, Michael Sterling, former federal prosecutor also, and Holly Waltman. Welcome to you all. The divorce rate is 50% in this country. Molly, is it 50%?
Maybe more or less 50%, but it's
Okay.
not just divorce. His son had committed suicide. He was under incredible stress from the entire situation. We have a 2-hour confrontation in a parking lot. We don't know what led exactly to that moment where he snapped.
Oh, wait. Molly, how much time does it take to all right, because he didn't come to the argument with the gun. He has to get the gun, right? Doesn't that take a little bit of time of reflection, a little time to plan what you're going to do? Because I'm going to get the gun because I'm going to use the gun.
I mean, that's the question for the jury right now. Was this premeditated? You can think about it is this in cold blood, a thoughtful killing? Or is this just spur of the moment, losing your mind, heat and passion, and just a momentary lapse of reason that results in the death of another? And that is exactly the question for the jury. How much time are they going to consider when it comes to premeditation and forethought? Was this a murder with forethought or not?
Molly, to me, when the children testify, I don't know how many cases I have covered, whether they're adult children, young children, Harvard-educated children, or aerobic instructors. It doesn't matter. For the most part, I would say 19 times out of 20, children believe in the parent who's on trial. That's not the case here.
No, and I noticed immediately her referring to her father as the defendant, and that does speak volumes to the jury. Her testimony was incredibly compelling. It's just tragic. She's lost her brother, her mother, and her father is going to jail. The question is basically, I think, how long? And it's just tragedy, begetting tragedy, begetting tragedy.
Molly Parmer, criminal defense attorney, your reaction to what you just saw?
I think it's reprehensible. And I think that viewer is correct in her comment. This does not correct behavior of a 6-year-old who's throwing a tantrum. And I have an issue as well with what you pointed out, Vinny, in terms of the timing of this arrest. The child is sitting in a school administrator's office at this point, seemingly calm. And so to come in and arrest her, and you don't have this temporal connection to her quote-unquote offense versus this punishment, that makes this seem capricious to her. It doesn't make sense to her. She is 6 years old. This is not how you modify behavior, if there's even an argument that her behavior was deserving of some sort of modification to begin with. I think it's horrific to watch.
Ashley writing tonight, the officer was rude. Molly, that officer had discretion as well, right?
Of course he had discretion. And also the news has reported that the Officer Turner in this case, not only arrested the 6-year-old girl that day, but later that same day made another arrest of another elementary school student. And the Orlando prosecutors had since dismissed both cases, but this was a bit of a pattern for Officer Turner. And there was even a comment captured on his body cam footage later that day where he says something like, arresting the 6-year-old is a new record for him. This is not an appropriate mentality. We have a huge issue.
Not at all.
With the school-to-prison pipeline in this country, and this is a prime example of that problem.
I want to turn to my in-studio guests now to get their take on this plea agreement. Attorneys Anastasio Menendez and Molly Parmer still with me now. Thank you both for lending us your expertise. Molly, what do you think in terms of fairness for both sides? What's your take on it, please?
Well, I think it's interesting because Bonillo is 20 years old. So for him, 30 years is different than it would be for, say, a defendant that's 60 years old. And I think he probably had some very heavy conversations with his attorneys where they reminded him of his youth and that he was facing life. And life is certainly very different than getting out of prison when you're 50, which is basically the situation we see today.
It seemed like there was perhaps an admission of guilt or something very close to it in terms of him saying that he was the one responsible for it. So today, when the judge dealt that blow to the defense team, do you think that could have perhaps factored into their decision to encouraging him to enter this deal? Molly?
I do think so. I know that these documents, the transcripts of these quote-unquote confessions are redacted, but we know that not only did he admit to the shooting, but he also said that the deceased had pulled a gun on him first. And so I think one way that seemed to be unpredictable in this trial was the fact that we have Florida stand your ground law. It's very broad and it allows you to use proportional force in that situation. So I don't know how much that weighed in the defense's decision making and counseling their client, because you have this very extreme law in Florida that allows you to use proportional force if somebody pulls a gun on you, and the defendant said somebody pulled a gun on him in his confessions.
Right.
So it's somewhat unclear.
All right, now I want to bring in my special guests I have in the studio with me, criminal defense attorneys Molly Parmer and Anastasios Manetas. Thank you both for staying with me, watching that interview. I want to talk to you both about the Me Too movement and how it affects what you do in the practice of criminal law. Tell me how you deal with it in trials, in day-to-day practice, how you embrace it, and what might you do if you were on the Weinstein team. Molly.
I mean, you're right, it does impact jury trials like the Weinstein trial in a new and different way. We've had women come forward. We know that they might have harbored these instances as secret in the past, and now there's this push to come public with it and divulge details that maybe you haven't divulged in decades. However, the Constitution doesn't say that you have due process unless and until 90 women come forward and accuse you of something. It says that everybody has the same rights. And that's what the defense is emphasizing in this trial as they're going through jury selection. It doesn't matter that he had upwards of 100 women come out during October of 2017 and allege that he did this. It just doesn't matter. What matters is that in that courtroom, he is getting his constitutional rights. And that's what you do as a defendant, as a defense attorney, when you're representing somebody like Weinstein. You make sure that he has those rights no matter what.
Yes, well said, Molly. Don't you think would you do it if you were the defense team? Would you talk a little bit about the movement and what's going on and try to narrow the focus into the courtroom? Molly.
I think you have to. I think you have to bring it out in opening, like you said, and carry it through, but treat it in a way that gives the jury some sort of sense that you're aware of it and you care about it. But look, we still have the burden of proof and we still have a job to do. You have to convict him beyond a reasonable doubt based on the evidence and the testimony before you, and that's it.
Okay, joining me to discuss, criminal defense attorney Molly Parmer, and from our New York studio, civil rights attorney Clarence Pollard. These witnesses establish the creep factor. They raise it up a little more with every person that comes in with another story of Mr. Weirdo. They're effective, aren't they?
I mean, I guess the prosecution is trying to show that Mr. Weinstein's motive was to encourage young women to sleep with him so that they could get roles in Hollywood. But what it's also showing is that these women, unsuccessful actresses, waitresses at the time, were willing to meet with this man time and time again after he had allegedly assaulted them. And then these allegedly non-consensual acts happened. And I think it goes both ways. It shows maybe his motive for the prosecution, but it's also showing the motive of these young women to continue to surround themselves with somebody like this.
If you believe the witnesses that at that moment where he is engaging in unwanted sex, when they're saying no and he does it anyway, that's rape, no matter what happened before or after, right?
Well, I mean, arguably under the law it would be, but in this case, these witnesses, these Molyneux witnesses, Miss Dunn and Miss Wolfe, are not named in the charges. What's before the jury is not whether or not Miss Wolfe was raped. And so that should not be a question. The question is whether or not this establishes pattern for the sexual predator charge, and the defense is going to have to be very clear in their argument to not be distracted by some of this testimony.
But aren't they really extensions of Mimi Halle and Annabella Sciorra, and their stories mirror them? And if you're a juror, you're going to take things from them and just human nature, you're going to mold them together, which the state wants on some level, but maybe the defense wants it too.
Right, because what's consistent among all of these women, all of these allegations, is that after something happens, initially, something harrowing, some unwanted touching or masturbation or something like that, they go and continue to visit him again. They're willing to go to hotels and see Mr. Weinstein a second time. That's consistent as well.